Namaskar and a very good morning to one and all present here in this magnificent auditorium of Odisha Judicial Academy. Today, we are extremely privileged and fortunate to have amongst us a great legal luminary of our country, Honorable Mr. Justice ADARSH Kumar GOEL, former Judge, Supreme Court of India. We extend our heartfelt welcome to His Lordship for accepting our invitation and to be kind enough to grace this occasion. May I now request His Lordship to kindly adorn the dais. My Lord, please. My Lord, we are really obliged to you for having accepted our request to attend this lecture session at Odisha Judicial Academy on the subject of life of a judge, which I am sure will be very, very enlightening for all the new generation judges who have gathered here. My Lord, we express our gratitude to you, my Lord. I am deeply honored and privileged to welcome Honorable Mr. Justice Subhasis Talapatra, Chief Justice, High Court of Orissa, and the Patron-in-Chief of Odisha Judicial Academy. The idea behind holding this kind of a lecture session was first conceived by His Lordship. Lordship, we are deeply obliged and honored for your benign presence here. I take this opportunity to welcome the Honorable Judges of the High Court of Orissa who are present here despite their busy schedule to encourage us. My Lords, your presence means a lot to us. Thank you, my Lords, for being present here. I also welcome respected Registrar General, sir, and the officers of the Registry of the High Court of Orissa for their presence and cooperation. This lecture session is organized for the benefit of the guidance and welfare of the 50 Civil Judges Junior Division now under provision at Odisha Judicial Academy and the fraternity of the Civil Judges Junior Division posted in all parts of the state. Today, we have 120 officers joining us physically from across the state. I welcome all of you. And I also welcome all the judicial officers who are watching this program live through the YouTube channel of the High Court of Orissa. Thank you very much for being here today. I welcome all of you. I also welcome all the officers of Odisha Judicial Academy and our sister concern, Odisha State Legal Services Authority, for being here today. Thank you everyone for being here. Before moving ahead with the program, I consider it to be my extreme privilege to give a brief introduction about chief guest and the cynosure of this occasion, my Lord Honorable Mr. Justice ADARSH Kumar GOEL, former Judge, Supreme Court of India, and the former Chairman of National Green Tribunal. His Lordship studied law and got an LLB degree from Punjab University, Chandigarh. He enrolled as an advocate with the Bar Council of Punjab and Haryana on 16 July 1974 and commenced practice before the Punjab and Haryana High Court. His Lordship was a litigator and a member of the bar for 27 years from 1974 through 2001, during which period he conducted matters across a wide range of subjects. While still a young advocate, he unhesitatingly and successfully defended liberty and civil rights of a large number of victims of the emergency period during 1975 to 77 against unreasonable and political detentions. He eventually shifted his practice to the Supreme Court of India and enrolled as an advocate on record in 1979, having stood first in the examination. He represented various parties to the litigation, ranging from the states to vulnerable groups in the society, such as farmers, teachers, workmen, and labor unions, and had a substantial pro bono practice. While at bar, he also served as an additional Advocate General of Uttar Pradesh, Senior Counsel for the central government, Haryana, Gujarat, and Himachal Pradesh governments. He also served as a standing counsel, civil, for the Delhi government. In the Delhi High Court, Supreme Court designated him as a senior advocate on 11 February 1999. In his illustrious career, His Lordship got elevated directly from the bar as a judge of the Punjab and Haryana High Court on 2nd of July 2001. From 2nd of May 2011, he was appointed Acting Chief Justice of Punjab and Haryana High Court. From 12th of September 2011, his lordship was transferred as the senior-most judge to Guwahati High Court with jurisdiction over 7 states at that point of time, followed by his appointment as Acting Chief Justice, and then from 2012-2011 as the Chief Justice. From 12th of October 2013, his lordship served as the Chief Justice, High Court of Orissa, till his elevation as a judge of the Supreme Court of India on 7th July 2014. At the Supreme Court, his lordship led the Arrears Committee for reducing the pendants of litigations. As a judge of various high courts and the Supreme Court of India, his lordship authored a large number of judgments, many of which are groundbreaking decisions leading to institutional reforms. In the field of arbitration, judgments to which his lordship is a party include issues of jurisdiction, scope of interference by courts, interpretation, extent to which lawyers from foreign jurisdictions can represent, etc. On superannuating from the Supreme Court of India, on 6th July 2018, his lordship was appointed chairperson of the National Green Tribunal, the apex body, the apex tribunal for environmental matters in our country. His lordship completed his 5-year term in the said position on 6th of July 2023. His lordship's decisions in NGT cover multifarious aspects of environment, including climate change, waste management, air pollution, water pollution, noise pollution, land pollution, mining, industrial accidents for violating environmental safety protocols, protection of coastal zones, eco-sensitive zones, forest, wildlife, biodiversity, protection of water bodies, extraction of groundwater, environment impact assessment of various projects, and revamping and monitoring mechanism for compliance of the environmental norms. My Lord, we are deeply fortunate to have you amongst us. Thank you for being here. Before we begin the lecture program, let me convey our gratitude in these words. The Sanskrit verse says, Vidwatvangcha nrupatvangcha na eva tulye kadachan swadese pujyate raja vidwan sarvatra pujyate. Lordship, we are deeply privileged and honored to have you amongst us today. Your commitment, dedication, contribution to the justice delivery mechanism in India, both at bar and at bench, are second to none. As a mark of our deep reverence, gratitude, and regard, we would like to felicitate the scholar and the teacher in you in this momentous occasion at Odisha Judicial Academy. To do the honors, may I humbly request my Lord, Mr. Justice Subhasis Talapatra, Chief Justice, High Court of Orissa, and the Patron-in-Chief of Odisha Judicial Academy to kindly felicitate my Lord, please.
Stand there. Stand there and speak.
Thank you, my Lord. May I now have the honor to request my Lord to kindly start the lecture session, please. My Lord, please.
This one is it required?
No.
Good morning, everyone. Odisha High Court. I am not naming all of you individually, and my very dear other judicial officers who are present here. Let me first thank the Chief Justice for giving me this opportunity, which I was not expecting, particularly once I had retired, and I never thought that I'll be asked to give any lecture, which I may not be very good at. But Chief Justice, with whom I have association for the last almost 12 years, and when we were together in Guwahati, we have sat on the bench together for a long time, and I learned about him when I went there. He was an eminent lawyer on all sides in Tripura bench earlier, and then Tripura High Court, and very creative and unique in his own ways. Qualities which are very, very unique. In fact, he is a scholar and knows various branches of law and also about life, about literature. I am in fact a very common man. It's a different thing where you reach, you become judge, etc., or go to higher echelons in the system. That is by default. Sometimes it happens accidentally also. But he told me that I should come, and neither I can say nor I could not say no also. And in fact, I felt privileged and honored on being asked to come and give lecture. Whatever I may be able to tell you, it may be of any value or it may not be. Let me be very clear. It may or may not be of much value, what I say. But certainly I will make an attempt in sharing with you whatever I think. And he has given, Chief Justice has given me adequate time. Normally, always the speaker is being told your time is over. There's the next speaker or there's the next session. So I have become used to that speak for 5-10 minutes and then you are being told to stop speaking, etc. But today, it is otherwise, that you go on speaking as much as you want and there's no interruption. So what I will suggest is that I don't want to go on speaking. I will speak a bit and then I will like all of you to participate. Is it acceptable? Because we have young people and young people have their own wisdom and new ideas, new thoughts. So why don't we share it? Normally, there is a hesitation in judicial officers in speaking before the judges. Now, I am a retired person, don't bother. Therefore, you are free to speak and you can speak your mind. And particularly if you ask questions that will provoke me to speak more. All right. So first of all, the topic, very beautiful topic, very beautiful, I must say, is the life of judge. Life of judge is a real topic. We go on speaking about various legal subjects, civil procedure, criminal procedure, or even constitution or different laws. But we don't talk about life of judge. It's an explorative topic. It requires some original new thinking. There have been so many eminent judges. Their biographies are there. It is possible perhaps to understand the life of judge by reading several biographies of eminent judges. And what is that aspect of life which is most important is a question. So I will now proceed one by one in small points. I delivered almost for the first time lecture before new judicial officers in August 2011, when I was acting Chief Justice of Punjab High Court. A large-scale judicial officers recruited, and I was required to give an address. At that time, I had thought of some points which are still in my memory. I will touch those points. Thereafter, when I went to Guwahati, some refresher course was going on. The moment I went there, I was asked to address them. And then, if Justice Talapatra will recall, there was no recruitment. I went to district Dibrugarh and inspected the jail, which is one experience I will like to share with you. And I had devised my own method of judging the judicial officers working, and also to find out what is the state of affairs going on in the district court, in the administration of justice. It was found to be very interesting also. When I went to Dibrugarh with Justice Rishikesh Roy, who is now Supreme Court judge, he was the portfolio judge of that district. So I told the district judge, Mr. Ali, who became High Court judge later, I told them that you divide all the under trials according to the presiding judge, and give notice to the public prosecutor, keep the files ready of all the under trials. I will have a brief interaction with the under trials and the presiding judge and public prosecutor, and also read the file, read the Jimny orders, how the trials are being conducted. From there, I will get an insight what is happening, whether trial is progressing properly, whether under trial is getting justice, and what should be done. That is also an opportunity to give training to young judicial officers, because magistrate's post, let me tell you, is most important, where liberty of very, very ordinary common man is in question. And since there is time, I will take few minutes on that aspect also, which is also part of training. So, how to remand a person to custody? You have all undergone training? All the judicial officers sitting there? They have completed their training? Training is going on? They have not yet started working. Oh, I see. One batch. 50 officers. The rest of them are okay. Okay. So some have undertaken training, some have not undertaken. That's good. So I have interacted with judicial officers in Odisha Academy also earlier. And I'll be very happy to discuss some of the fine points. And also tell you the reason where I got that idea. Have you heard of Husainara Khatun case? Any one of you who has heard? My expectation is all of you must have heard, must have read it. That is my expectation. But is it that nobody has read? That is a surprise to me. Why it is a surprise? Because this judicial academy owes its existence to Husainara Khatun. Okay? What happened is, in Bihar, there is a place called Bhagalpur. So that's how during the interaction, so many things will come. I will share with you also. I have not planned any lecture as such. You may have heard, you may not have known, because it was long back in 79 or 80. I was also that time a young lawyer. Bhagalpur is a place where there was some big criminals, big time criminals. Okay. What administration thought is to tackle them, they blinded them in jail. Okay. It came in media on which Supreme Court took suo moto cognizance, Justice Krishna Iyer or Justice Bhagwati. I think Krishna Iyer. So I was at that time a young lawyer, only used to watch the proceedings without much briefs with me. Okay. Husainara Khatun was some journalist or some prisoner, perhaps. It is the case is in that name from 1979 or 80, 81. There are many judgments, series of judgments given in that name. I am very, very surprised that in law colleges it is not being taught. And there Supreme Court expressed a lot of disappointment with the working of magistrates in mechanically failing to protect rights of under trials, and recommended and directed setting up of judicial academies so that before a person takes over as magistrate, he must be given basic training. Now, don't misunderstand. Let me express my disappointment if you have not read Husainara Khatun. Not only that, 5 years back, when I was about to retire from Supreme Court, we had a bench in Supreme Court with Justice Lalit, myself and Justice Lalit, who was my old friend as advocate. In fact, we had a common chamber as advocates. And we had a common bench for more than 1 year. He and I went to China on an official visit. And when we were coming, we were discussing the issue of under trials. So I told him, because he had never practiced in district courts, nor he had worked as a judge in High Court. So I told him, you should know how the district courts, how the magistrates function. So I told him, you come with me to a jail, and in jail, if you see the files of under trials and orders passed by magistrates, it will give you an insight how magistrate is working. This was in 2018. And I said, nearest place to Delhi is Faridabad. He was very excited. Yes, let us go. You please take me. So I told him another thing, that our system, to what extent our system is a failure. I was inspecting judge of Faridabad as judge of Punjab High Court in 2008. And I had given an inspection report of which I got a copy and shared it with Justice Lalit. And I said, if you see, even now, the failures will be almost same. And you will be surprised. I'm telling a dark picture of our system. We were surprised to find that magistrates were still suffering from same failures as recorded in my 2008 report. Then we talked to the magistrates. I am now retiring. I had about a week to retire only. Don't bother. I am not taking any action, but why don't you improve? And it's a lesson, I think, for judges of Odisha High Court also, in overseeing the working of the trial courts, because justice is not done in High Court only. Substantial justice is done in trial court and mainly magistrates court. So I was telling you the experience of Dibrugarh. I will tell you what happened, how when we saw the files, what we found. But one great thing happened was, after the inspection was over, in respect of cases of all the officers posted there, there were still so many under trials left. And I asked the district judge, who are these under trials? He said, they are under trials of vacant court. I was shocked. How can there be under trials of vacant court? Sir, there were some magistrates who have been transferred, and then no replacement has been given. There is a huge amount of work here. So therefore, these are cases which are not being handled by anyone. So it was a matter of great surprise to me, because in my lifetime as judge, I had never come across that there are under trials. I said, in whose custody they are? They are in judicial custody. So the court master takes remand order from anyone and they are kept in custody. No progress is taking place. It may be surprise to many of you also, but that was a fact. Then from there itself, I decided and directed the district judge there and then, right now, they must be assigned to some court. We as judges can't play fraud. We have to protect people's life. And if you are sending a person to custody on remand, it is a very, very serious thing. It can't be done so light-heartedly that a court master goes and obtains signature and the judge mechanically signs remand him to custody for 15 days and then again repeated. In 1953, there is one Supreme Court judgment which deprecated this, and they said this is passing parrot-like orders. Because in that case, the file produced by Supreme Court, it was remanded to custody, remanded to custody, remanded to custody. All those orders are quoted in 1953 judgment, which I read at long time. So then I discussed with Justice Rishikesh what is to be done. He says, sir, the problem is there was a judicial academy in Guwahati, but the Prime Minister Manmohan Singh, who was MP from Guwahati, Rajya Sabha member, he had given a promise in election to set up NLU. And then he sent a personal DO letter to the then Chief Justice to give the Judicial Academy building for the NLU. Till new NLU building is set up. So the Judicial Academy building was given to the NLU. Therefore, no recruitment is taking place. So on that very day, we made a plan that all recruitments will take place in a time-bound manner. We fixed a date on which the judicial officers will join also, and worked out the details backward. And strictly we followed that schedule and made appointment of 119 judicial officers. They said, what will happen? There is no academy and there is no faculty. Then I said, I told you very clearly, I am not a scholar. I said, I will be one-man faculty and my house will be the Judicial Academy. Okay. If we can work out, we will work out. Otherwise, this will be the arrangement. Because situation is emergency. People are being kept in custody without anybody's application. So I actually wanted to tell you my experience of giving lecture in Judicial Academy. So all that is incidental to that. And then we started the academy in Guwahati at that point. It's a different matter now. There is a full-fledged academy. I have not yet visited, but there's a full-fledged big academy now. And NLU campus, which was inaugurated when I was there. So the point real is, and I'll also tell you one or more stories of Guwahati before I go back to Punjab and then go back to Husainara Khatun and then switch over to the next thing, because this is a first point which emerged. because of academy, why academies have come, and what is the role, and what are the serious mistakes being committed by magistracy throughout India, which need to be addressed on war footing. And this was the feelings of Krishna Iyer and Bhagwati in 1980, and we are now 45 years back and still there, is not something which should continue. Justice Sangam Sahu has long experience of trial court working even as an advocate on the criminal side. He must have seen what is happening if the magistrate is not competent. What will happen? So I'm telling you another thing before I come to the subject. I went to Aizawl, Mizoram, and Justice Ujjwal Bhuiya was the inspecting judge. He is also now Supreme Court judge. Okay. He was basically a tax lawyer. But after becoming judge, you go to all the subjects. That's the life of the judge. So I went to Aizawl. There was large number of judicial officers recruited there because of Supreme Court direction, fill up all the posts. So we first held a meeting of the judicial officers in the court complex. I think 39 judicial officers. So we asked them what is happening, what are the issues, what are the problems. They said, sir, we have no work. This is our problem. We come at 10 o'clock and sit in court for about 15-20 minutes, half an hour. There is no work here. So don't do any other further recruitment. And do something by which we can do work. So I had that Dibrugarh thing in my mind. I said, what about criminal cases? There's no criminal cases here. What about jail? So we don't know. We have never gone to jail, never visited. Is there under trial? To our knowledge, there is no under trial. Even district judge said, registrar of the High Court also. All right, I said, tomorrow in the morning, we will visit the jail in Aizawl. So next day, we went to the jail. Called the jail superintendent. The sequence was first called senior citizens, people above 80. Are there any under trials? Then women. And then those in custody for more than 2 years. This was the sequence we followed. Many senior citizens under trial. Women, large number of women. It was a great shock to me and Justice Bhuiya. And all judicial officers were with us. And they also, we asked district judge, you said there is no under trial. There are such large number of under trials. I said, in whose court these cases are going on? The judicial officer said, no, not in my court. They were not even aware. When I asked jail superintendent, bring the record. Who has remanded them to custody? Okay, then I showed the signature to the district judge, then found out who has remanded. So I don't know. But you are signing remand orders sent to custody. Then we asked the prisoner, how you are going on? Have you appeared before the court? No, sir, I never appeared. Then we asked the person who was taking them to court, called them. It was just a mystery to solve the mystery. So, sir, I'm taking them in bus every day. Okay. And wherever the cases are there, I go and present the list to the court master. And the judge is in chamber. And court master goes and on the printed remand orders, obtain signatures from the chamber and give it to me. And the under trials remain sitting in bus and they are brought back and lodged in jail again. This was a startling thing and a shocking thing for me because I had come from Punjab. Such things don't happen there. At least there were more established systems. Even in Odisha, it is not happening. I'm only telling you of northeastern states where there was no proper judicial system at one time. And so particularly remote states like Mizoram, etc., there were no systems. So then it was a wake-up call, and Justice Bhuiyan understood the situation. He said, Chief Justice, you give me 1 month's time. I have understood the problem. And within 1 month, things will be streamlined. All these cases within 1 or 2 months will be disposed of. They were mostly cases of liquor, excise. There is a prohibition there. And under Excise Act, some bottle of liquor people are normally drinking. And whomsoever they want to arrest, police people arrest. But they were there for 1 year, 2 years, even beyond the sentence, because no magistrate ever applied mine, or cases were not properly put up. But that situation was not there in Tripura when I went with Justice Talapatra to visit Agartala jail. Things were in order by and large. Or in Odisha jails, things were by and large in order. So what happened in Husainara Khatun, the famous Bhagalpur blinding case, it is known in criminal law, is that some people were blinded when they were in custody. And the plea of the police officers was, so they are serious criminals, they are repeatedly committing crime, this is the best solution. Blind them, they will not commit crimes. So we have done it for the protection of the society. So Krishna Iyer and Bhagwati, in those judgments, they totally rejected this approach and required compensation to be paid and their treatment to be done for restoring their eyesight in All India Institute. And also fixing timelines for completing speedily under trial cases, mainly relying upon the then recent judgment in Maneka Gandhi, where speedy and holding speedy trial to be part of right to life. In Maneka Gandhi, for the first time, right to life was given a very expanded meaning. Anything which makes life meaningful is right to life. Even right to get a passport was part to be held to be not only right of movement, right to go abroad, was held to be part of right to life. So expanded meaning of right to life in Constitution in 21 is one great advancement of constitutional law in this country. Landmark development, you can say that, because that changed the lives of the people. So that will also be a lesson and will have nexus with the subject of life of judge. We are not talking of a judge or B judge. It is the judge who has changed the life. Life of judge is that which changes lives of the people. In short, so while discussing the subject, one point which is very important is how life of people can be changed by the judge. So Husainara Khatun is one historic judgment which each and every magistrate must read and understand thoroughly. Because 167 Criminal Procedure Code, which talks of remand during investigation, and I think 309 is after investigation. Because these days memory may not work properly, but as trial lawyers 30, 40 years back, these were the provisions which we were always remembering. But these are pleas for any magistrate, whether your training is complete or not. Please don't ignore these two provisions of Criminal Procedure Code and the history and further developments which have taken place and which are still taking place in criminal law. because that touches the life of common man. When and how to send a person to custody. I'm also telling you another interesting thing in Guwahati which happened is, I was addressing my judicial officers. Sir, we are told that the constitution has nothing to do as far as trial judges are concerned. Is that the thinking here? Is constitution relevant in your working? Can anyone point out? No, not relevant. Relevant. Why it is relevant? How it is relevant? So is speedy trial part of right to life? In which provision of CRPC? Is there a provision of CRPC which says that? No. Then how do you enforce it as judges? Has any one of you read P.R. Ramchandra Rao judgment? Are Supreme Court judgments relevant for judicial officers? Okay, not relevant. So what are those Supreme Court judgments which are basic? Let me also share with you another shocking thing. After Shetty Commission, service conditions of judges changed. And now all further promotions are selection posts. Earlier it was automatic. So when this happened, because once we become judges, we stop reading. Let me be very frank. Don't take it as a criticism, but I'm telling the examples. We were to promote civil judge senior division to the post of superior judicial service. Okay, additional district judges. So there were 15 posts. I'm telling you something on record, factual thing. We called 45 officers in Punjab 3 times. I was heading the committee, 5-member committee. So my 4 members told me, sir, we will not supersede anyone. It will demoralize the judicial office. Let us give promotion mechanical. They knew my views were slightly different. But I am little rigid in certain matters. I said, all right, we'll do that. But we will ask 3 questions. I will not ask. Any of you may ask 3 questions. And if any one question is correct, then that person will get promotion. If no question is correct, then they will be superseded. Is that acceptable? They said all right. So one of the members asked, every candidate, he asked same question. Tell the name of any 5 Supreme Court judges. So all first 30 were not able to tell names of 5 Supreme Court. So he was so shocked. He said, sir, I withdraw my suggestion of giving mechanical promotion. And I'm now telling you, unanimously, without my intervention, the decision of committee was to give promotion to judicial officer from 31 to 45, superseding 1 to 30. So please don't take your career so lightly that you stop reading Supreme Court judgments. Because two judgments which I have asked you, to Sanara Khatun and P.R. Ramchandra Rao, if you don't know it, it may be difficult to say that you are fit to be magistrate. Please, today itself you read it if you have not read. Or if any one of you has read it, please point out. So P.R. Ramchandra Rao is a judgment of 7 judges of Supreme Court, most landmark judgment, where the question is how a trial magistrate will give effect to Article 21 of right of speedy trial. How much delay is too much delay? How much delay violates citizens' right? Recently, I read a Supreme Court judgment giving compensation to a under trial for failure of the magistrate to decide the trial within reasonable. There may be time that you may be required to personally pay if you are so incompetent. So the judge has to know, like a surgeon has to know how to use the knife while conducting surgery, otherwise you will kill people. So a judge has to know minimum law. That is first requirement. Otherwise, better sit at home. Otherwise, you will be committing heart surgery or brain surgery without knowing how to use the knife. Okay. Will you follow this? Will you read these 2 judgments today? No. How many? Raise your hands. 10%. Now 20%. What about remaining 80%? They will not like to read. Then you will be committing crime if you continue as judges without knowing basic law or your duty. So what is happening is, if you don't know this much law, you will mechanically give remand and keep people in jail and violate their right of liberty. You will violate the Constitution. You will violate the law. How you will protect the law? How you will protect people's rights if you don't know what their rights are? Okay. So this is the state of affairs which we find when you go to the jail. If you see the file, the date will be given. Long date will be given. Person is in custody. So why long date is given? Sir, no witness is coming. Is it the fault of the accused? What is the offense committed? 379. All right? Or 379/511. How much will be the sentence? There is a theft of cycle. How much will be sentence? I want to ask you also. Though the subject is life of the judge, but I have shifted to the functioning of the judge. Okay? A cycle, somebody wanted to commit theft of cycle. But the owner came and took it back and lodged FIR. The man was arrested. Is there in custody for 2 years. No challan is filed, no charge sheet is filed, no witnesses come. What will the magistrate do? Please tell me. How will you apply the law? What law you will apply? Anyone can speak? Give the mic.
Please speak up. Why are you sitting there?
So we have
Yes.
it is the under trial under section 436A CRP.
Under
436A CRP.
436, that means you will grant bail. You will grant bail. Whole 36 is a bail provision, but you will remand him to custody, supposing he doesn't give bail. He doesn't sign personal bond. He says, I don't want to be released on bail. What will you do? I'm not testing your knowledge. I'm just asking a question. Anyone else will like to attempt? I'm not discouraging you. You have given a partly correct answer. That's one way, 436A. Anyone will like to tell what is 436A?
Sir, 436A was added in 2005.
Yes.
It's the situation that where a prisoner has already served half of the punishment or full of the punishment, that is the maximum prescribed for that particular offense of which he is accused of, then it is his right to be released on bail.
Correct.
And sir, apart from this, sir, we can compel the prosecution or insist the prosecution to complete the trial in a speedy manner so that.
All right. Thank you. Now, will anyone like to share his experience how far 436A is successful in tackling the problem for which it was enacted and why? I will tell you some experiences, some interesting experience. See, there are in IPC many provisions which give even life imprisonment for small offenses. Misappropriation of 10 rupees or 100 rupees. How much is the sentence? 409. Life. All right. So the person undergoes 3 years of custody. Then 100 rupees is the misappropriation, but no progress in trial. What will be the approach? 436A doesn't apply. The person is in custody and is a poor person. So this is where Article 21 comes in. This is where Husainara Khatun comes in and P.R. Ramchandra Rao comes in. Okay. So what you have to do is not merely understand what the letter of law is. Mechanically, the judge doesn't function mechanically. What is the object of judge? What for is the judge there? Is judge computer? We are talking of artificial intelligence. Can artificial intelligence replace a judge? I'm telling you a very interesting thing which happened in this academy here in the year 2017, 6 years back. There was a seminar in Odisha Judicial Academy on the subject of sentencing. I don't know whether any one of you retired. Of course, Justice Talapatra was not in that seminar. I'm not sure whether Justice Sahu was there. So I had also participated. There were many speakers. I was one of the speakers. I had only few minutes time. I was not so well prepared. So I was reading on Google to speak something, taking the help of Google. And on that day, on the Google, I found speech of Barack Obama, who was that time president, on sentencing. Okay, he is also a lawyer from Harvard, if you know. Many speakers were saying, let us follow American sentencing system. Our sentencing system is defective. And what is the defect in our sentencing system in IPC? Maybe sentence to imprisonment up to 7 years, up to 10 years. So it can be 1 day, it can be 10 years. There's no guideline. This is a very defective system. One court may say, all right, 1 day till rising of the court. And one judge say 10 years. So everybody says, follow American system. They were reading American sentencing manual. Okay. And I read Obama's speech. Then I read out from the Google, from my mobile, that this is the most backward or most thoughtless system which America is following. They have a sentencing manual. All right, theft, 5 years, 5 years. That's all. No discussion with the judge. Theft may be of 1,000 rupees, theft may be of 1 rupee, theft may be of 1 million rupees. 5 years. Trespass, 5 years. So the judge will mechanically say, all right, you went to the house, it was a trespass, you committed theft, it was theft. So 5 years plus 5 years, 10 years. Will it be good system? Went to your house and took 10 rupees or took an apple. In American court, he will follow, he will get 10 year sentence, mechanical. Nobody will interfere. Another thing I'm telling you, American thing, in American law, magistrate's order is practically final in the whole system. Even death sentence of the trial court is practically final, because right of appeal doesn't include right of oral hearing as of right. Appeal is sent online. The appellate judge looks at the papers, and 90%, more than 90%, he doesn't interfere. And in 10% where he is to interfere, he indicates how much time he will hear arguments. Supposing he says 12 minutes, it will be strictly 12 minutes. It can't be 13 minutes. Okay. And there are, every higher court has number of cases which he will take up, not beyond that. Quick decision is there, but remedies are not like the remedies which we have. And artificial intelligence which we are propagating can be very dangerous, which is being followed in China. Everything is decided by computer. The judgment is typed in 1 minute on the screen. The judge is sitting. He speaks certain facts and the judgment is there. So human brain can't be replaced. These may be dangerous things when they come unless there are adequate safeguards. How important the judge is for society, for people. How much respect a judge gets. And what is important about judge? Is it his power? Is it his dress? Is it his bungalow? What is important? You are a member of society also. As a member of society, what do you expect a judge to be? I don't normally give any quotation, but I have one small one-line quotation before me, which was part of my speech which I had given somewhere. There was eminent Chief Justice of America, Warren Barron. Okay. He said, people are not interested in great dress or great building. People are interested in fair and quick justice. What is the emblem of the Supreme Court? Anyone has read? Beautiful, beautiful. So how do you know what is dharma? How do you find out? It's a very charming word and important word. Yato dharma tato jaya. Simple. Sanskrit, but not difficult even for Odia speaking people. Yato dharma means wherever there is dharma. Dharma means justice here. Tato jaya, there is the victory. So victory is always on the side of justice. But then how do you identify what justice is? Is it easy to find out what justice is? Or difficult? And then how he will get victory? The person who is suffering injustice, the judge knows he is suffering. I'll tell you one or two instances and then ask you. Another place I went when I was in Guwahati, because it's a vast area. And we have in Punjab, it's a normal practice for judges to visit prisons. That's a traditional system going on since long. I tried to introduce it in Odisha also. Some judges, I took them to jails. Also to show them how the system is working to understand. Another place in Guwahati, very famous and big, is Silchar. Why I went there is, when I was monitoring in Guwahati criminal cases, criminal appeals, they said, sir, there are large number. I said, any 10-year-old appeals? Sir, there are 10-year-old appeals from Silchar. I said, why? There are 3 districts in Assam where official language is Bangla. Court language is also Bangla. So they said, sir, there is nobody to translate. People know Odia, people know English. From Odia, English translators are available. So those criminal appeals are listed. But there's nobody to translate Bangla to English. Therefore, there's so many appeals are pending. So I said, but there are Bangla knowing advocates. They can do it. No, they are not willing to do it. I call them, I will request them. I called them to my chamber. I said, I have a small request to make. Can you translate some Bangla judgments into English and evidence? Sir, we will do it once you are saying. I said, you will get payment advance. Whatever payment you want, you think is a fair remuneration, you take it in. I told the registrar, make payment straight away first and get these translated within 1 week. I fixed the timeline and all were translated and those appeals were taken up. So what is happening in trial? So the trials also long time takes place because some judicial officer posted there don't know Bangla. They go on giving date. So this was the anomaly. I visited Silchar and first Silchar jail. Justice CUTTACK was the inspecting judge there and asked, are there any under trials or persons in custody above 80? So jail superintendent said there are 2 persons who are above 80 and they are disabled. 2-3 people are required to move them also. They can't even go to bathroom. Why they are being kept in jail? Also, they are given life sentence. When the offense was committed, they were young. By the time proceedings ended and it is decided they have crossed 80 and they are suffering from diseases. I had also called legal aid advocates to jail to take their assistance. I said, how will you help them? What remedy they have? So, sir, we have no remedy. They were seeing only in CRPC. That's a notion that you don't go to Constitution, you only go to CRPC. So they have already been, a Supreme Court appeal is dismissed and they have hardly served for 6-7 years. Nothing can be done. Okay. So I said, why you are forgetting 21? Why are you forgetting Article 161 in the Constitution? What for is the constitutional provision for remission? System is not helpless. There are powers. Why can't constitutional jurisdiction under 161 be not exercised to give remission? The district judge said, sir, we have never read these provisions. We are also not aware. And I told the legal aid advocates, draft an application. I will dictate it. Act as a lawyer. And give it to me right now. I will pass orders. Under which provision? They didn't know. Now, I will ask you, what will be the provision by which they can move the High Court? Will anyone like to answer? What remedy will be available? Under which provision, even if court is willing to give remedy, under which provision? Anyone has heard of Article 226? What is that? So can a writ be issued? What is the limit on writ power? Read 226. What is the limit? What is the power? So I asked legal aid advocate, write a petition under Article 226, directing the state to make a policy for remission in cases where persons are disabled or unable to move, and their relatives are prepared to take them, and they are not danger to the society. Those who can't even move about. And an assessment is made. Will it be valid or invalid? Supposing a policy is made by the state that a person who has crossed 85 years can't even go up to the toilet. No purpose is served by keeping him in jail. Can there be a policy? Under Article 161, can there be a policy? Does it appeal to your common sense? I was also reading one more quotation, I will tell you. Small quotation of one line, which you have already heard. Life of law is not logic. It is experience. You have heard it? So is logic relevant or irrelevant? Why it is said logic? Life of law is not logic. What does it mean? Life of law is not logic doesn't mean logic is not relevant. Life of law is not logic means not merely logic. Logic, yes. But logic and experience both. How to apply law. Right? So if you think it is not irrelevant, a policy can be made. Why can't High Court ask state, what is your remission policy? And why can't this be part of your policy? Okay. So I asked him to draft petition under article directing the state to prepare a logical and reasonable policy, including releasing people who are not danger to the society, who are disabled, who are of cut-off age, etc., etc. I said, I will pass order. I am assuring the order, you only file petition. So the petition was filed and order was passed, which is a matter of record. The order was the state of Assam will prepare within 3 months an appropriate policy which should also consider this aspect and place on record of the court. And pending such policy or such response, the so-and-so prisoner on recommendation of district judge and inspecting judge is released on personal bond and send them home immediately. Was it a correct order or incorrect order? Did it bring about some justice or some change in life of the particular person? So, life is nothing but experience. Life is nothing but your perception, how to go about. And perception will require you to know the things, to read the things, to understand the things, to be sensitive, to understand where injustice is, to understand where pain is, and to go an extra mile. This is the difference in judge or in a bureaucrat, or I'm not saying bureaucrat is bad, just saying that as against anyone else, or I'll say shopkeeper or anyone. Is the life of judge different or same? Is it distinct? And if it is distinct, why? Some people say so and so was a good judge. Why they say that? We have put up so many, I think, pictures also. Judges who are not even in this world. We are still remembering. Why? What have they done? They say he is embodiment of justice. What does it mean? You read the biographies of judges which are easily available, and I will recommend to the Judicial Academy to bring about some soft copy version or some version which doesn't require someone to spend money, and read the lives of the judges. Very interesting and very educated. And each one of you may be remembered or may like to be remembered as judge who did something. Will you like to be remembered that way? No. All right. I think you may not be answering, but you will like to be remembered. Anyone who will not like to be remembered that way? Nobody is raising the hand. That means you want to be remembered as people who did something. That is my understanding from your face. If I am making a correct judgment. So what you will have to do for that? It is not necessary you should write a biography or somebody else should write a biography. But the pleasure which you can get. Money gives pleasure? Yes, it does give. To some extent. Comforts, material comforts, how much pleasure they give? They do give to some extent. But are there any other things which give you pleasure which are not material? There are non-material things. You know, when I was in Odisha, I visited Swaranpur, near HON'BLE. Went from Angul, then Swaranpur. Then next day I went to Hirakund Dam also in HON'BLE. Okay. When I went to Swaranpur, and Justice C.R. Das, who is now in Calcutta, he belonged to that place. His house is there. He took me to his house also. So there was some photo, many places I saw. I asked Justice C.R. Das, brother, whose photo it is? There was some Swaranpur new court complex which I had to inaugurate that day. So he says, it is photo of Bhima Bhai. He belonged to this place. So who is Bhima Bhai? I never heard his name. And there was something written in Udiya under his name. I said, you tell me in Udiya what is written. You may be conversant. Anyone is conversant? Please tell. Tell in Udiya, please. So he was a great poet. He was a great spiritual person. He was blind. He was born in a poor family. And perhaps as per caste system, It was low in hierarchy of that time. It was 400-500 years back. And after death of his father, his mother performed second marriage and abandoned. So he became a beggar. Young child, 5, 6, 7 years, no place to go, no guardian. Then I asked what happened then. I went to some ashram. And this Swamiji said, "Who is this boy? Turn him out." How he has entered the ashram. So the boy was disappointed and jumped into a well out of frustration. I visited that well also, where he jumped. Then people came running and took out the child. And Swamiji also realized the mistake and he took the child to the ashram. He said, "Don't run anywhere, I am your guardian." Then slowly, he was there and Swamiji was there. So he told Swamiji, "Can I do some kirtan which you are doing?" Yes, at the age of 8 or 9. Then he did kirtan. Then from there, when he started kirtan, the crowd started increasing. Slowly, there was huge crowd to participate in kirtan of a young boy. His voice was so melodious. So people were enjoying, getting happiness without money. More happiness what they will get from getting money or from getting food or any other comforts. They were all coming from different parts of Odisha. They were coming. Even outside Odisha, people were coming. And what was the 2 lines? "Send my soul to hell, condemn my soul to hell." That is his only demand.
I may be excused that those 2 lines, sir.
Yes.
Just
Yeah,
that
yes.
Those lines are Praninko Arato, Dukha Apramito, Dekhu Dekhu Keba Sahu, Mo Jibana Pache, Narke Padithau, Jagata Uddhara Ho, which means that
I will translate. I will translate. There are so many miseries. How you can see it? You can't even see it. How many miseries? Eh? So please redeem these miseries. Solve these miseries. As far as I am concerned, I may even go to hell. I don't care. Can anyone think that way? That I don't care, only solve miseries of others, send me to hell. People go to temple, "Oh, give me moksha, give me this, give me that." But he was getting immense happiness in making this kirtan or this prayer. And this prayer is addressed to whom? That is now a question I'm asking you. To whom is this prayer addressed? To Lord? He didn't believe in Lord. You know his life? The power that may be, who is that power? You are that power. It is addressed to you. Where is Lord? Nobody has seen. I'm not saying there is no Lord, but some people say, and according to the literature, Bhima Bhai did not believe in any God. He believed in powers, invisible powers. He was not calling it God. Which are invisible powers? You are the invisible power before whom people suffering miseries come. Are people coming to court happy people or they are suffering? Is it happiness to come to court? Is it a pleasure to come to court? or it's a last resort? So can you convert the suffering in their eyes into a smile? What Mahatma Gandhi said. Wipe out the tears of the eyes. Can you wipe the tears of the eyes of anyone in your life? Do you have that opportunity? You have that power. And if you use your power to wipe the tears of eyes of a suffering person, unjustly suffering person, wrongly suffering person. Now, what you will have to do for that? You now tell me that. How will you do it? I will ask you to read one more judgment today. I will not ask you too many. I have already asked you two. One more I am asking you. Please note down. I humbly request you to read these three judgments. Okay. One is Husainara Khatun, 1979. You give the citation, 1979. Huh. P.R. Ramchandra Rao, 2002. Okay. Read it carefully. The sensitivity there. I'm not saying don't read more. You can read more. Third judgment I am asking you to read is S.P. Gupta. Okay. Why I am asking you to read? The citation I am having, 1981 supplement SCC page 87 or AIR 1982 SC page 149. Okay. I will also give you para numbers and tell you why I am asking you to read. And then I will take few more minutes. Perhaps you may get bored. And if you want some question answer that can be gone, you can go on. Or if you have more time, I can go on for some more time. Okay. Okay, sure. So I'm only now, for the time being, telling you this judgment in S.P. Gupta, where particularly about the life of judge from para 27, about the functions of judge, para 27, Justice Bhagwati. I'm only reading one line which I noted. You can read the whole. The function of judge is to transform status quo ante into a new human order. This may be Bhagwati was a brilliant scholar, etc. I am talking in a very, very simple language. Okay. A creative function. They've also used the word social engineering. Of course, that may perhaps be when you become constitutional court judges, where you have to deal with mass actions, etc. But the spirit is same. Here also, don't think trial court judge is to act mechanically. No. All right, I will ask you only. Is there any innovation in trial court? No innovation? Mechanical? There is a couplet in Urdu. If you pardon me, I am provoked to say that. उठेंगे तो हम बन के तूफान उठेंगे, अभी हमने बनने की ठानी नहीं है. When I do, I will do great wonders. But I have decided not to do anything for the time being. Okay. So is it that you have passed a resolution not to do something for the time being? All right. If that is the resolution, your choice for the today. But I'm sure when you decide, when you resolve, you will do wonders. It is for you to decide when you do that. But you can do wonders. Okay. In the judgment, which I just now mentioned, S.P. Gupta, the issue considered was basically appointment of High Court and Supreme Court judges. For the time being, that time issue arose whether the central government has primacy in appointing, because Article 217 of the Constitution says President will appoint a High Court judge. Okay. But it also says Chief Justice of India will always be consulted. What does it mean? That was the basic question there. I'm just telling you, if you have not read. While considering that question, there is also a discussion what the judge is expected to do. So that discussion I will like you to read. In fact, I was reading that discussion, and there it was 7-judge bench. All the judges have written their separate judgments, most of them. And one judgment is by Venkat Ramaiah, who became Chief Justice of India later, and whose daughter is now Supreme Court judge, going to be Chief Justice also, Nagaratna. Okay. So when I was reading Justice Venkat Ramaiah's judgment, the last part, he was junior most in that bench in 1982. And his judgment is the last in the report also. And it ends with a Sanskrit shlok, because a scholar of Sanskrit, Venkat Ramaiah, where he has quoted from a famous writer, poet, Bhartrihari, of Gupta period, 8th century. Bhartrihari, Niti Shatkam, I am not asking you, you must read, it's your choice. It's a very small book of 300 shloks. It is called Trishatkam. 3 means 3. Why? Shatkam means 100. So 300 it is because it has 3 chapters of 100 each. Marvelous scholar he was. In that, first is Shringar Shat. Very interesting to read. Means what is the value of romance in life? How much pleasure romance can give. You will be highly enjoying it. You please go through that. Shringar Shatram. Worth reading. Then Niti Shatkam. Niti Shatkam is what are the principles of life. Enjoyment is one thing. What are the principles? And Justice Venkat Ramaiah has quoted 84th shlok from Niti Shatkam. Ganchantu ya yatha ichham adyeva marnamastu yugantreva nyayat patha privichalanti padam nadhira. Okay. And Justice Venkat Ramaiah quoted Shloka 84 from Niti Shatkam to say that this is meant for judges. Judges should have these qualities which are mentioned in this shlok. They should follow these principles. Okay. Yes. So I think these are the points which guide us, which mold our personality, our thinking. Ultimately, every action, every order follows your thinking. So you have to develop a thinking, a judicial approach, a just approach, a fair approach. to be proactive in doing justice, going a step forward. Why? Because that will give you happiness. That is your real function. When you perform your duty fully, that gives you happiness. And that is why this Justice Venkatramaya was a great Sanskrit scholar, has quoted this particular shlok. And as suggested by the Chief Justice, we can have a break. And I can make a couple of points and also go into question and answer. But I have some simple points also. If you are not bored, I will continue. If you are bored, we will stop here and go to question and answer. Okay? Thank you. Okay, right. Yes.
We'll take a short break and resume sharp at 12:15. Thank you. Please take your seats and keep your mobile phones in silent mode. We'll just start the session right now. Lordship, please.
We should go up to 1. So we have another half an hour. And one of the questions which I want to now deal with is how to balance the rights of the accused and the victim. That's one of the pertinent questions, apart from any other questions which you will like to ask me. But before that, whatever a few more points I wanted to mention. Some of the points which have been discussed in the earlier part of this session are about the up-to-date knowledge which is required as a tool. You want to do justice, you want to advance justice. But how do you do it? You want to do it is one thing, but how do you do it is a question. What are the tools? Knowledge, yes. Logic to some extent. But then along with the logic, experience, not plain logic, not mechanical logic, not like a computer. Quick decision. Important? Is it important? Quick decision? What will you expect as a litigant? Supposing you have a problem and you are a litigant. Imagine, don't be a litigant, but supposing you are, place yourself, wear the hat, thinking hat, that you are a litigant. What will you do? What will be your expectation? Your behavior. How important is the behavior? I will tell you one experience, interesting experience. I went to a court in Punjab as a portfolio judge. And I went to the court campus, nobody knew me because I was practically from Delhi and newly I had gone to Chandigarh after a long period. So the lawyers did not know me. I was taking a round and also sitting in the area where litigants sit in simple dress. My idea was only to see how people are thinking about court. and try to address any wrong feeling in people's mind to inspire more confidence. So people told me many things. I was mixing up, sitting with the litigants, talking in their language. What are your problems? Why you have come? What is your experience, etc. It was very educative. They told me many things. I asked them who are doing well, which is the judge, who is the judge whom you like and why? Who is the judge whom you don't like? Things like that. Just to educate myself. And it was very interesting. Very interesting things litigants told me about different judges. One young lady judicial officer, many people told me very, very good things about her. I was much impressed by the things which were told to me in her absence by litigants in normal way. So I told the district judge, I called her to the circuit house. I asked him, she should meet me. So she came. I did tell her what I had heard. I asked her, how do you have XYZ qualities? So I was very surprised to find, without any training, she was young judicial officer of 2-3 years standing, and she was so popular. So it doesn't require much training. It's inherently there. Sir, I get up very early in the morning. I read all the files. I conduct my court in such a way that I don't offend anyone. At the same time, I am quite tough. I don't adjourn cases. So I said it is very difficult to keep everyone happy these days. At least my personal experience is I have never been a popular judge. So it's all because if you are conscious, you're thinking you are accountable. Normally people think what is there, once in a year, High Court judge will come, he will write the ACR. At the end of the matter, if there is no complaint, that's all the life of a judicial. I'm talking about judicial officers. Of course, constitutional court judges work in a different way. So it's all a matter of your choice, basically. What is in your mind? What is your mission? It's all personal. If you decide, if you are determined, you have to do well. Your salary will remain same. Your prospects will remain same. You may not get anything extra by performing better, except your own satisfaction. Some people are happy always. They should be happy. We are not against anyone's happiness. They can be happy without performing also. What is your expectation from yourself is a question if you ask every day in the morning. What is my expectation from myself? Why I am here? If you can ask yourself this question, it may be of great help to the people and to you in your mission. Ultimately, there is no other secret. I am openly saying, declaring it on the basis of experience. If you determine and you honestly ask yourself what I have to do, that's enough. That's 100% success guaranteed. You ask, you answer, you act. That's all. Is it difficult? I'm now not asking you to read anything. When you get up in the morning, ask yourself, what is your mission? What is your expectation? What is your destination? What is your route? And charter your route for yourself. Charter your destination. Solutions are not difficult, but asking yourself is difficult. Why should I ask? Where is it required? Have you been required? Is it your service condition that you will ask yourself? But if you ask, if you are interested, if you want success, you ask. It's your choice. It's optional. Do you read Gita? Arjun is confused. Should I kill? Or should I be killed? Should I start the war? He's powerful. He has capacity to kill. He has capacity to win. And he has support of winning. He's a winning candidate. He wants to run away. So what is the advice given to him? That is Gita. Don't run away. Determine for yourself what is your duty and do it. Don't bother about the consequences. Only do. I'm not able to do. There is a saying, I don't know, I have not read, but I've heard. Very interesting saying. Janami dharmam name pravritti. You have heard? No? Janami adharmam name nivritti. What does it mean? I know what is right, but I don't want to do it. My tendency is not to do it, though I know it is right. I know what is wrong, but my tendency is to do it, even though I know it is wrong. So who can remedy that? Is there any doctor available? Can any doctor do it? You are the doctor. Who are you? Have you asked yourself, who are you? Have you read Bhaj Govindam? Who are you? Shankaracharya was asked, who are you? Went to his guru. You introduce yourself. Who are you? So every power is there within you. If you ask yourself, who are you? Ultimately, you are everything. And it is your determination. So ultimately, you have to be clear what your mission is. You have to be clear what are the tools for that mission. And the last tool is to ask yourself, am I doing it? If I am not doing it, what more I need to do? And answer it yourself and do it yourself. That's all. So, main question before a judge is how to balance the justice. As I said, the question in the context of balancing the crime, the victim, the criminal, is facet of balancing justice. You must have seen or heard, he is a pro-landlord judge. He is a pro-revenue judge. He is a pro-accused judge. He is a pro-environment judge. What does it mean? That means not balancing properly, having a particular bias, having a particular tendency, can't be helped. Some traits, some tendencies, your sense of justice will always tilt you. Some people say he's a pro-poor judge. Judge is basically pro-justice. But perception of justice can be. And the person who is watching may feel he is a convicting mind. May say he is a convicting mind. Okay? So, whether you have to be bothered about the perceptions or you don't have to be bothered is another matter of choice you will have to make. You will ask yourself for right answer. It's not arrogance, not ego. But you are truly asking yourself. Asking yourself means what? There is a divine power within you. Something now established. I'm not talking religion or spiritualism. It's an established fact, proved fact. There is some higher power within you. Bal Gangadhar Tilak was tried. The judge was under compulsion to punish him. He had no option. And Tilak also in open court said, you have no option. All right, you do your duty. Send me to jail. He was sent to Mandalay jail. But he uttered some words which have become immortal. And Bombay High Court, after 1947, some people wanted those words to be inscribed. And there was a division in the bar and bench, whether it should be written or it should not be written. Ultimately, it was written. And they are there. If you visit Bombay High Court, these words In spite of verdict of jury, I maintain I am innocent. There are higher powers that rule destiny of men and nations. And it will be the will of providence that cause which I represent may prosper more by my suffering than by my remaining free. So it's also the higher power want that I may be punished, though I am innocent. All right, do it. I was reading very interesting lecture of Aurobindo. It's your choice. You want to read it. It's available on Google also. In text form also. Hard copy is also available. Soft copy is also available. Audio is also available. It's available with me. I can give you. Aurobindo, as you know, was a brilliant person, very brilliant person. Ultimately, he settled down in Pondicherry and Aurobindo Ashram, we know it. He was contemporary of Vivekananda and the same eminence which country has produced. Aurobindo was one. He was tried for conspiracy for murder in 1905. He was arrested. He was falsely arrested. He was falsely implicated, falsely tried, and of course acquitted. So his speech, he says, when I was arrested, I was restless. What is happening? Why I am being arrested? And then I was taken to jail and kept with the criminals. I was very much upset, though he was a religious person, believing in God. And then said, God appeared in my thinking that I have got you arrested. Don't worry. Remain in jail. Then I was relaxed. Maybe it is divine power, so I can't help it. And then I was preparing for my defense all the night. That these are the cross-examined questions, etc. Witnesses, false witnesses were introduced. And I was briefing the advocate who was engaged, preparing to brief him. Suddenly, some other lawyer came. He said, I am appearing for Aurobindo. He said in court. I did not know who that lawyer is. But I saw Lord Krishna in the lawyer. And who that lawyer was? Do you know? He was S.R. Das. And the questions which he had been preparing were in his pocket. He took out the paper. All those questions which Aurobindo was writing were in his pocket. Then he saw the judge, the English judge. He was misbehaving with him. But he said, I saw Krishna in him. And ultimately he acquitted him. So there is a divine power within you. You have to understand you are divine. You are exercising divine power. Only thing is, be sure. Not be arrogant, but be sure. It is the divine power which is working within the judge, and respect it. Connect yourself with it. So there are difficult questions. Very difficult questions will come before the judge. But if he is sure he is divine and he is doing nothing but taking the help of divine power, solutions are found. How to balance? I'm just quoting few lines about how to balance. There is a Supreme Court judgment where very beautifully this question is discussed. And I'm giving you the citation, but confined myself to advising you to read 3 judgments. 4th is your choice. But since this question is there, this interesting judgment is there on balancing. 2018-17 SCC 324. Okay. 2018-17 SCC 324. Acharya Maharaj Shri Narendra Prasad Ji versus State of Gujarat. That is, of course, balancing fundamental rights. Only analogy can be taken. It's for constitutional court. How a particular fundamental rights cannot exist in isolation in watertight. How to balance one fundamental right with the other. One fundamental right may have to coexist in harmony with the exercise of another fundamental right by others, and reasonable and valid exercise of power by the state in the light of directive principles in the interest of social welfare as a whole. The court's duty is to strike a balance between competing claims of different interests. Articles relating to fundamental rights are all parts of integrated scheme in Constitution, and their waters must mix to constitute grand flow of unimpeded and impartial justice, social, economic, and political, and equality of status and opportunity, which may imply absence of unreasonable or unfair discrimination between individual or groups or classes. There can be 2 individuals both having legitimacy to a claim or assert a right. Factum of legitimacy is primary consideration. It has to be remembered that no fundamental right is absolute. It can have limitation. Permissible limitations can be imposed by the state. Limitations are to be within the bounds of law. When there is intra-conflict of rights conferred, like fair trial, the test is it should be paramount collective interest or sustenance of public confidence in the justice dispensation system. If collective interest or public interest which serves the public cause has legitimacy to claim for asserting a fundamental right, then it can be put forward that the right should be protected. The right of victim for fair trial is inseparable aspect of Article 21. When they assert the right of themselves as part of collective, concept of public interest gets galvanized. Public interest has to be given primacy. It promotes rule of law. It may be clarified once the primacy, which is based on legitimacy and public interest, is judged on facts of each case. It will require studied scanning of facts, competing interest, and ultimate perception of balancing will serve larger public interest. There's the ancient Sanskrit saying, Yadapi Siddham Lok Viruddham Na Adarniyam Na Acharniyam. So what is not in public interest can't be accepted. So mission for service is the mission which will guide. Ultimately, there can't be rigid formula how you balance. Individual fact situation will guide you. Because you can neither be pro-accused nor pro-victim, you are pro-justice. In one case, the justice will tell you to go in one direction. In another case, justice may tell you to go in another direction. Ultimately, with that mission of doing justice, you can find a solution in the facts and circumstances. That guide is sitting within you, but you will have to think. Mere logic, mere statutory provision, mechanically, is not enough for doing justice. It is thinking, it is your clear conscience, it is your determination to do justice. Are the vague, so to say, to some extent subjective, to be applied to objective parameters, to objective data which is available. Some extent of subjectivity can never be ruled out. But subjectivity is not yours. It is of the divinity within you. How to separate the two? That means, apart from your conscious mind, you think over coolly. Place yourself in both positions. Give a thought in the inner layers of your mind. When a difficult situation comes, apart from reading, it can't just come without reading. You have to be conversant with law. You have to be conversant with the facts on the file. And within that purview, you have to be guided by your higher powers within you. Clear mission before you to help the interest of justice and the victim. To differentiate, and I will end by quoting very important shlok from Gita. That is, what is the role of judge? Is in that shlok beautifully described in Gita. Paritrayanaya sadhunam vinashaya cha dushkritam dharam sansthapanarthaya sambhavami yuge yuge. That is chapter 4, shlok number 8. Okay, that God is telling, and that God is within you. God within you is telling. There's no other God. Paritranaya sadhunam, to protect the innocent, vinashaya cha dushk, and to punish the guilty. And thereby, dharam sanstapana, to do justice. What is to be done is to protect the innocent, to punish the guilty. But that you have to determine. That's a continuous task. And the tools are your knowledge. Knowledge is power. Knowledge you have to acquire. There is a knowledge or information or logic, and there is a knowledge within you. There is a logic within you. Both are to be tracked and brought in harmony. Then you will be functioning successfully as a team. Thank you. All the best.
Since we have come to the end of the lecture session, I would like to request any of the participants, if you have got any questions to put to my lord, you can please put your questions right now. Yes. Any person having any question, please come forward. Please come forward. Yes, sir. Yes, sir.
My Lord, Namaskar. I'm Siddhant Mishra, JMFC Sambalpur. My Lord, my question is with respect to presumption of law. There are certain acts, certain statutes where there are presumption of law in favor of any of the parties. For instance, 139 NI Act. There's a presumption in favor of holder in due course of a check. So, as a judge, what should be the amount of objectivity that we should be exercising while balancing the rights of accused here in this particular case with that of the complainant? Because the entire course of trial seems to tilt in favor of the holder in due course in such circumstances. So in such difficult situations, how do we look or how do we safeguard the interests of accused or what should be the amount of objectivity that should go into while disposing of a petition that is put forth by the accused or seeking an adjournment? That's my question. Thank you.
Any other officer would like to put any other questions? Anyone else, please? Rabi. Nanda.
My lord, namaskar. Myself, Prijit. My question is, my lord, with regard to the as all of us as an individual have like and dislike, which can also be called prejudice or bias. But while determining or taking a decisions, we are ought to not to impose those bias, as also highlighted by my lord during the lecture. But how do you identify those bias in the process?
Any other questions? Please come forward. We are actually running short of time. Please come forward. If anyone, Bimal Lakshmi Madam. On karo.
Pranam to all. Sir, today's topic is life.
Please identify yourself first.
Sir, myself Bimal Lakshmi Chaudhary, JMFC Kodala from Ganjam. Sir, being a human, judge were also human. So far as regarding the life of a judge topic is concerned, we want to know how to balance our life.
Anyone else, please? Okay, thank you. Anybody else would like to say something? That's it.
Thank you. You have asked 3 questions, which are all very important. The first question is a question which frequently arises and will always arise. What is presumption? It is defined, and you must have read in the Evidence Act what is shall presume, what is may presume, what is conclusive proof. Of course, these are 3. Some provisions say when this is proved, this will be conclusive proof. Conclusive proof means no evidence to the contrary can be permitted. Shall presume means unless contrary is established. So contrary can be. May presume or may not presume, that's a matter of common knowledge, right? So that is not difficult. This part is not difficult. Section 114 Evidence Act says court may have regard to common course of circumstances, common course of events. That's very general because common sense, always there, yes. Court is not debarred. Inferences can be drawn, but inferences can't be in the air. Can't be without any foundation. From the material, you have to link by your process of logic. Very, very interesting judgment of Justice Subba Rao. Best known judgment till now on this question is Kundan Lal Ralaram. You must read it if you want answer to this question. Again, it is your choice. I can give you the citation, AIR 1961, page 136. Just now I saw from Google when your question was asked. Very beautiful, elaborate discussion by Justice Subbarao. When we were students, we were told to read this judgment thoroughly on burden of proof and on presumption. The very detailed discussion. And as you know, Subbarao's style of writing, till date, nobody has matched this judgment or articulation in this judgment is the best. Okay. So you can draw inference from facts, from proved facts, from documents. Facts which are before you, maybe in terms of oral evidence or maybe documentary evidence, but from there, certain things flow automatically. Once it is proved it was daytime, many things will follow. And many things may not follow. 114 Evidence Act permits you to go further, move further. Right? And how balance shifts, to what extent balance shifts, on whom it is, burden is there. The civil case, how, criminal case, how, if it is burden is on prosecution, to what extent burden is on accused. All these rules of game are defined in section 100, 101 onwards in the Evidence Act, or in particular statute, like you said, in NI Act, yes, holder in due course. Means I have signed a check and given to you. You are holding the check. So I can't say you have stolen it. You don't have to prove it. You are holding it. Your name is written on it. So presumption is, if I have issued a check of 1,000 rupees, I am liable to pay you 1,000. I can say 1,000 is written. It was written by mistake. It was written for X reason or Y reason. Then I will have to prove it. Because presumption is rebuttable presumption. It's not a conclusive proof. Is that all right? You study this Kundan Lal. The other thing you have said is the bias. Yes. People may be motivated in terming you as biased. You are bound to take decision one way or the other. One side may be happy, one side may not be. It's not your concern. You can't please everyone. It's a difficult job you are doing. But once your conscience is clear, then be ruthless. Can't help it. If somebody is unhappy, somebody is saying, I am biased, let him say that. It's beyond your means. Credit, discredit is beyond your means. You do your duty, whatever is the result, then leave it to the Almighty. Right? What is the third thing? One more thing. One more question was there? Balancing between personal life. Personal life. Person. As it should be your life. Your personal life, yes, your duties are there. That's balancing, I have told you, is for you to think. Your own thinking will guide you. That balance. You will ask yourself and you will get it. Balancing is such a question which you will have to answer. Only tools for answering the question is thinking patiently, thinking coolly, thinking with detachment. You will get the answer. Nobody else can tell. Because there can't be a fixed answer. It will depend again on the data, on the situation. That's my personal. Thank you.
Thank you, Lordship, for your kind answers given to the queries and questions put by the judicial officers. With this, we have come to the end of the lecture session. Before closing the session formally, I would like to announce that Honorable High Court of Orissa is now providing all the judicial officers with state-of-the-art gadgets to help and assist them in their judicial work. In this series, the judicial officers now undergoing training at Odisha Judicial Academy of 2021 batch will be provided with state-of-the-art HP Jet laptops. And as a token, we will be distributing the laptops to some of the officers, and all the officers can collect the laptops later on from office. And may I have the permission of His Lordship, and may I request Lordship to kindly hand over the laptops to some of the officers, please. My Lord. May I request Ms. Adyarsha Mishra to kindly come on stage, please. To be followed by Mr. Binayak Prasad Sahu and Sri Animesh Jain. I would now request my Lord to kindly hand over the laptop to Ms. Adyarsha Mishra of 2021 batch. Thank you, my Lord. Mr. Binayak Prasad Sahu, please. Thank you, ma'am. Mr. Animesh Jain. Thank you, my Lord, for doing the honors. May I now request Honorable Mr. Justice Subhasis Talapatra, Chief Justice, High Court of Orissa, to kindly come on stage and hand over laptops, please. My Lord, please. I request Ms. Smruti Abhilasha, Mr. Richi Milan Patra, and Ms. Dipta Sethi to kindly come on stage, please. Ms. Smruti Abhilasha. Thank you, ma'am. Mr. Richi Milan Patra, please. Thank you, ma'am. Ms. Dipta Sethi, please. Thank you, my Lord, for doing the honors. With this, we have come to the end of this lecture session. It's my duty to now extend vote of thanks. At the outset, I express my deepest regards and gratitude to Honorable Mr. Justice ADARSH Kumar GOEL, former Judge, Supreme Court of India, and former Chairperson of the National Grim Tribunal, for his Lordship's benign presence here and for the valuable words of the advice that he has given to all the officers. And I'm sure that this advice will help the judicial officers in perform their duties in a better manner. I'm confident that the participants got immensely benefited from the lecture that they just heard, and they just lived the moment. Thank you, my Lord, for being here today and guiding us all through. We are obliged. I express my gratitude and sincere thanks to Mr. Justice Subhastis Talapatra, Honorable the Chief Justice, High Court of Orissa, and Patron-in-Chief of Odisha Judicial Academy for being the anchor of this program. It was His Lordship's idea that I could be able to figure it out and make the necessary arrangements with help of all my associates. My Lord, we are deeply obliged and thankful to you. Thank you, my Lord. All the honorable, I'm sorry, all the honorable judges of High Court of Orissa are present here despite their busy schedule. Their presence has surely encouraged the participants to a great extent. Thank you, my lords, for your presence today. I thank all the participating judicial officers for being very attentive and disciplined audience. I also thank the judicial officers who have joined us through virtual mode. I also thank the respected Registrar General, sir, and the officers of the Registry High Court of Orissa for all the help and assistance extended by them. I thank all the invited guests, ladies and gentlemen, for being here today. I'll not make much of your time. On behalf of Odisha High Court and Odisha Judicial Academy, I express my gratitude and thanks to all of you. Thank you very much. With permission of the chair, the program is now declared closed. Thank you. I request all the participants to kindly join us for a group photograph at the portico, followed by a lunch. I request all the honorable high dignitaries also to kindly join us. My lords, please.